Judge mocks Barron Trump in court only to be shocked by his genius legal skills. Before we dive in, kindly hit the subscribe button and let us know where you're watching from in the comments. The courtroom of Washington, D.C. was packed to capacity, buzzing with anticipation. This wasn't just any legal battle. It was Barron Trump, the youngest son of former President Donald Trump, standing alone at the plaintiff's table. At just 18 years old, he had made the surprising decision to represent himself in a high-profile defamation case against a major media outlet. People whispered and took photos with their phones while reporters scribbled notes, all of them wondering the same thing. Why would someone with access to the best lawyers in the country choose to fight this battle alone? Judge Raymond Miller entered the room, silencing the crowd with a bang of his gavel. He was a stern man in his 60s who had seen all types of cases during his long career. When his eyes fell on Barron standing alone at the plaintiff's table, a smirk appeared on his face. "Mr. Trump," Judge Miller began, adjusting his glasses, "I understand you've chosen to represent yourself in this matter." Barron, standing tall in a well-fitted suit, simply nodded. "That's correct, Your Honor." A wave of chuckles rippled through the courtroom. The judge leaned forward, not bothering to hide his amusement. "You do understand that legal proceedings are not simple matters? This isn't a high school debate class. There are rules, procedures, and complexities that take years to master." The laughter grew louder. Even the defense attorneys representing the media company Barron was suing exchanged smiles and knowing glances. "With all due respect, Your Honor," Barron replied, his voice calm and measured, "I'm well aware of the challenges. I'm prepared to present my case." Judge Miller raised an eyebrow. "And where exactly did you study law, Mr. Trump?" More laughter filled the room, but Barron didn't react. He simply waited for the noise to die down, his expression revealing nothing. Unlike many who might have been rattled by such public mockery, especially from a judge, Barron remained composed. His posture stayed straight, his eyes focused, showing a maturity well beyond his years. "I haven't attended law school, Your Honor," Barron finally answered, "but I've spent the past 6 months studying defamation law, reviewing relevant cases, and preparing my arguments." Judge Miller shook his head, clearly not convinced. "Very well, Mr. Trump, let's proceed, but don't expect special treatment because of your last name." As the room settled down for the opening statements, no one expected much from the young Trump, but Barron showed no signs of intimidation. Despite the judge's condescension in the skeptical audience, he remained calm, organized, and focused, giving the first hint that this case might not go the way everyone expected. Barron's lawsuit centered on a series of articles published by Globe Media Network, one of the country's largest news organizations. 6 months earlier, they had run a damaging story claiming Barron had cheated his way into college through fake credentials and family connections. The article had spread quickly across social media, with millions sharing and commenting on the false allegations. "Your Honor," Barron began, opening a neat folder of documents, "I'm suing Globe Media for publishing statements they knew were false. Their article claimed I used fake grades and family influence to get into college, when in fact I earned my place through my own academic achievements." He pulled out his official transcripts and test scores, which had been properly submitted as evidence. "These records show I graduated in the top 5% of my class and scored in the 99th percentile on standardized tests." The media company's lead attorney, Stephanie Reynolds, a sharp-dressed woman in her 40s, known for aggressively defending high-profile clients, stood up with a confident smile. "Your Honor, my client published an opinion piece protected by the First Amendment. Mr. Trump, being the son of a president, is a public figure who must prove actual malice." Judge Miller nodded in agreement, looking at Barron with skepticism. "Ms. Reynolds raises a valid point, Mr. Trump. Are you familiar with the higher standard of proof required for public figures in defamation cases?" Barron didn't hesitate. "Yes, Your Honor." Under New York Times versus Sullivan, I must prove the statements were made with actual malice, meaning they were published with knowledge of their falsity or with reckless disregard for the truth. I'm prepared to demonstrate exactly that. The judge's eyebrows raised slightly, surprised by Barron's accurate citation of the landmark Supreme Court case. The young man's decision to represent himself suddenly made more sense. He had clearly been studying. The reason I chose to represent myself, Barron continued, sensing the question in everyone's minds, is because this case isn't just about me. It's about standing up against media outlets that believe they can publish anything about anyone without consequences. Reynolds smirked. Very inspiring, Mr. Trump, but emotional appeals don't change legal standards. I agree, Barron replied calmly, which is why I'm here to present evidence, not emotions. For the first time, a flicker of uncertainty crossed Reynolds's face. This wasn't going to be the easy win her client had promised. Despite his age and lack of formal legal training, Barron Trump had clearly come prepared for battle. As the initial proceedings continued, Judge Miller made no effort to hide his skepticism about Barron's legal abilities. When Barron began organizing his evidence folders, the judge sighed loudly. Mr. Trump, Judge Miller interrupted, this isn't a school project where you get points for neat folders. Legal proceedings require understanding of complex procedural rules. The courtroom erupted in laughter again. Several reporters in the gallery exchanged amused glances, already crafting headlines about the teenager in over his head. Thank you for your concern, Your Honor, Barron replied politely. I've studied the federal rules of evidence and the specific procedural requirements for this court. The judge chuckled and shook his head. Reading a few rules online doesn't make someone a lawyer, young man. There's a reason people spend 3 years in law school and pass a difficult bar exam. From the defense table, Stephanie Reynolds decided to join in. Your Honor, while we respect Mr. Trump's enthusiasm, perhaps we should advise him that it's not too late to hire proper counsel. This case involves nuanced interpretation of First Amendment protections and defamation standards that seasoned attorneys find challenging. How thoughtful of you, Ms. Reynolds, the judge replied with a smile. What do you say, Mr. Trump? Perhaps you should reconsider your approach before we go any further. All eyes turned to Barron, who stood calmly at his table. Many expected him to show signs of intimidation or embarrassment, but his expression remained composed. I appreciate the concern, Barron said, his voice steady, but I believe I'm capable of presenting my case effectively. The facts are straightforward. Globe Media published statements they knew were false, causing significant damage to my reputation. The judge let out an exaggerated sigh. Very well, it's your right to represent yourself, even if it's not in your best interest. Let's proceed with opening statements, though I expect we'll be done rather quickly. He turned to the defense attorney. Ms. Reynolds, whenever you're ready. Reynolds stood and buttoned her expensive suit jacket. Your Honor, this case should be dismissed immediately. Not only is my client protected by the First Amendment, but Mr. Trump has failed to meet the basic requirements for filing a defamation claim. His complaint lacks specific details about actual damages, and as a public figure, he faces an appropriately high bar to prove his case. The judge nodded along, clearly agreeing with everything Reynolds said. When she finished her statement, he turned to Barron with a look that suggested he expected little. Mr. Trump, your opening statement. Try to keep it brief, please. Barron stood up, straightened his tie, and walked to the center of the courtroom, ready to deliver his first real test in the case. The mockery had been relentless, but now he would have his chance to speak. Barron Trump walked to the center of the courtroom with a quiet confidence that seemed to catch everyone off guard. While the room had been filled with chuckles and whispers moments before, a curious silence settled as he took his position. He carried no notes, no flashcards, just the steady gaze of someone who knew exactly what he wanted to say. Your Honor, members of the court, Barron began, his voice surprisingly strong and clear for someone his age. This case is about truth, responsibility, and the damage that can be done when a powerful media organization abandons both. He paused, allowing his words to settle in the quiet courtroom. Globe Media published an article stating that I cheated my way into college through falsified records and family connections. These statements were demonstrably false, and the evidence will show that Globe Media knew they were false before publication. Barron began walking slowly in front of the jury box, making eye contact with each juror. The Supreme Court established in New York Times versus Sullivan that public figures must prove actual malice in defamation cases. But the court also recognized in Gertz versus Robert Welch that even public figures deserve protection from knowingly false statements. In Herbert versus Lando, the court further clarified that a plaintiff is entitled to examine the editorial process when actual malice is alleged. The judge, who had been leaning back in his chair with a dismissive expression, suddenly sat up straight. Reynolds, the defense attorney, stopped writing mid-sentence and looked up with visible surprise. I draw the court's attention to Milkovich versus Lorraine Journal, Barron continued, where the Supreme Court held that statements presented as opinion can still be defamatory if they imply false assertions of fact. The Globe article repeatedly used the phrases sources say to disguise direct factual claims about my academic record as mere opinion. Barron reached for a document and handed copies to the clerk for distribution. In my evidence packet, you'll find a copy of my complete academic transcript, certified by my school, showing I graduated with a 3.95 GPA. You'll also find my standardized test scores, placing me in the 99th percentile. Both directly contradict Globe Media's claims. Judge Miller accepted his copy, examining it with newfound interest. The smirk that had been fixed on his face since the beginning of the proceedings had disappeared. Furthermore, Barron continued, I've submitted communications between Globe Media staff, obtained through discovery, showing that their fact-checking department flagged the allegations as unverified before publication, but editors chose to publish anyway. A murmur ran through the courtroom. Several reporters began frantically typing on their phones. The law doesn't require a law degree to seek justice, Your Honor. It requires evidence, facts, and the truth. And today I intend to present all three. Barron returned to his seat, leaving the courtroom in stunned silence. Judge Miller cleared his throat, clearly recalibrating his assessment of the young man before him. Well, the judge said, his tone noticeably different, that was thorough, Mr. Trump. From the defense table, Reynolds was already huddled with her team, whispering urgently. Their confident expressions had vanished, replaced by looks of concern. The gallery buzzed with excitement. This was not the easy dismissal they had expected. Barron Trump had just demonstrated not only a solid understanding of defamation law, but also the ability to connect relevant precedents to his specific case, something that would impress even seasoned attorneys. Judge Miller, who had been so quick to mock Barron earlier, now looked at the young man with a mixture of surprise and grudging respect. The case that everyone had expected to be over before it began was suddenly looking very different. Let's proceed with the evidence, the judge said, leaning forward with new interest. Mr. Trump, please call your first witness. Barron's first witness was Dr. Eleanor Wright, his former academic advisor and professor from the prestigious university he attended. As she took the stand, her credentials were impeccable. A PhD from Harvard, 30 years of teaching experience, and numerous academic awards. Dr. Wright, Barron began, standing confidently as he addressed his witness, could you please describe your professional relationship with me during my time at university? I served as Barron's academic advisor for 3 years, Dr. Wright replied. I also had him in 2 of my advanced courses. And in your professional opinion, How would you characterize my academic performance? Dr. Wright adjusted her glasses. Barron was consistently among the top students in every class. His papers were exceptionally well researched, his analysis was sophisticated, and his work ethic was remarkable. I have taught thousands of students over my career, and he ranks among the most intellectually capable I've encountered. Reynolds stood quickly. Objection, Your Honor. This testimony is merely character evidence and doesn't address the actual claims in the article. Barron turned to face the judge. Your Honor, the Globe article specifically claimed I was academically unqualified and incapable of earning my grades legitimately. Dr. Wright's testimony directly refutes these specific allegations. Judge Miller nodded, his expression thoughtful. Objection overruled. You may continue, Mr. Trump. Barron turned back to Dr. Wright. Dr. Wright, were you ever approached by anyone from Globe Media regarding their story about me? Yes, I was. A reporter contacted me approximately 1 week before the article was published. And what did you tell this reporter? I informed them that the allegations about your academic performance were categorically false. I offered to provide documentation of your excellent work and achievements. With your permission, of course. Did they include your comments in their article? No, Dr. Wright said firmly. They did not. I was surprised to see the published article contained none of the information I had provided. Barron walked to his table and picked up a document. Your Honor, I'd like to enter this email exchange between Dr. Wright and Globe Media reporter James Wilson as Exhibit C. As the emails were distributed, the courtroom fell silent while people read the exchange. The emails clearly showed Dr. Wright providing detailed information contradicting the article's claims, followed by Wilson's reply thanking her, but noting, this doesn't fit the narrative we're developing. Reynolds' team huddled together, whispering urgently. One of her associates frantically flipped through papers, looking increasingly concerned. No further questions for this witness, Your Honor, Barron said calmly. Reynolds approached for cross-examination, her earlier confidence noticeably diminished. Dr. Wright, isn't it true that as Mr. Trump's advisor, you have a vested interest in his success? My interest is in academic integrity, Dr. Wright replied firmly. I've failed students from prominent families before when their work didn't meet standards. My reputation depends on honesty, not favoritism. Reynolds tried again. But you can't possibly know if Mr. Trump received undisclosed help with his assignments, can you? Actually, I can, Dr. Wright countered. My advanced seminars include in-class writing assignments and oral examinations, specifically to verify students' independent abilities. Barron excelled in these controlled environments, just as he did in his take-home work. After several more failed attempts to undermine Dr. Wright's testimony, Reynolds returned to her seat, visibly frustrated. Barron then called his second witness, James Wilson himself, the reporter who had written the defamatory article. As Wilson took the stand, he appeared nervous, repeatedly adjusting his tie. Mr. Wilson, Barron began, when you interviewed Dr. Wright for your article about me, did she inform you that your allegations about my academic performance were false? Wilson shifted uncomfortably. Yes, but we had other sources. We'll get to those sources, Barron interrupted calmly. For now, I'd like to focus on your editorial decisions. After receiving contradictory information from a credible source, a tenured professor with direct knowledge of my work, did you include any of her comments in your article? No, we didn't, Wilson admitted. Why not? Wilson glanced toward his company's attorneys. Editorial discretion. Barron walked to his table and retrieved another document. Your Honor, I'd like to enter this internal Globe Media email thread as Exhibit D. As the emails were distributed, another murmur swept through the courtroom. The thread showed Wilson's editors explicitly instructing him to find dirt on the Trump kid and later telling him to leave out anything that makes him look good. That's not the story we want." Judge Miller read through the emails, his expression growing increasingly severe. He looked up at Wilson, then at the defense table, with undisguised disapproval. "Mr. Wilson," Barron continued, his voice remaining measured despite the damning evidence, "your publication has a policy regarding fact-checking before publication, doesn't it?" "Yes," Wilson replied, his voice barely audible. "And according to these emails, your fact-checking department flagged several claims in your article as unverified and contradicted by primary sources. Yet those claims appeared in the published version without any indication they were disputed. Is that correct?" "That's what the emails show," Wilson conceded. Throughout this testimony, Judge Miller's demeanor had transformed completely. The skepticism and mockery were gone, replaced by focused attention. He was leaning forward, following every exchange with intense interest. Reynolds attempted damage control during cross-examination, but Wilson's testimony had already severely damaged their case. The courtroom, which had initially been filled with people expecting to see a teenager embarrass himself, was now watching in amazement as that same teenager methodically dismantled a major media company's defense. Even the reporters covering the trial had stopped their usual whispered comments. They were witnessing something extraordinary, a young man with no formal legal training exposing journalistic malpractice with the precision of a seasoned prosecutor. As the day's proceedings ended, Judge Miller addressed Barron directly. "Mr. Trump, will continue tomorrow morning at 9 a.m. I must say your preparation for this case is impressive." It was a small acknowledgement, but coming from a judge who had openly mocked him hours earlier, it spoke volumes. The next morning, the courtroom was even more packed than before. Overnight, news of Barron Trump's unexpected legal prowess had spread, drawing curious spectators and additional media. People who had come expecting to witness a circus were now eagerly anticipating a serious legal battle. As proceedings began, Judge Miller's tone had noticeably shifted. Gone were the condescending remarks and skeptical sighs. Instead, he addressed Barron with the same professional courtesy he would extend to any attorney. "Mr. Trump, you may call your next witness," the judge said. Barron stood. "Your Honor, at this time, I'd like to call Ms. Rebecca Chen to the stand." A murmur of confusion spread through the courtroom. This name hadn't appeared on any witness list. Reynolds immediately rose to her feet. "Objection, Your Honor. This witness wasn't disclosed during discovery. The defense has had no opportunity to prepare for this testimony." Barron remained calm. "Your Honor, Ms. Chen only came forward yesterday after seeing news coverage of this trial. She's a former employee of Globe Media who has critical information relevant to this case." Judge Miller frowned. "Mr. Trump, you know there are rules about witness disclosure." "Yes, Your Honor," Barron replied. "Under Federal Rule of Civil Procedure 26E, parties have a duty to supplement disclosures when new information becomes available. I filed an emergency supplemental disclosure this morning at 7 a.m. and had it delivered to the defense team. This witness's testimony is crucial to establishing actual malice." The judge turned to Reynolds. "Did you receive the supplemental disclosure?" Reynolds reluctantly held up a document. "We did, Your Honor, but we haven't had adequate time to—" "I understand your concern," Judge Miller interrupted. "However, given the late discovery of this witness and Mr. Trump's proper filing of the supplement, I'll allow the testimony. The defense will be granted additional time for cross-examination if needed." Rebecca Chen was sworn in. She appeared nervous but determined as she took her seat. "Ms. Chen," Barron began, "could you please tell the court about your former position at Globe Media?" "I was a fact-checker in the research department for 3 years, until I resigned last month," she replied. "And were you involved in the fact-checking process for the article about me published on March 15? "Yes, I was the primary fact-checker assigned to that story." Barron approached with a document. "Is this the fact-checking report you submitted regarding that article?" Chen examined the paper. "Yes, this is my report." Can you explain what these red flags throughout the document indicate? Those mark statements that could not be verified or that contradicted available evidence, Chen explained. As you can see, nearly every claim about Mr. Trump's academic qualifications and college admission had a red flag. What happens when you flag content in this manner? Standard protocol requires the editor to either remove the flagged content or clearly label it as unverified in the published piece. And did that happen in this case? Chen took a deep breath. Number I was explicitly instructed to remove my objections from the final report. A buzz of conversation swept through the courtroom. Judge Miller called for order. Ms. Chen, who gave you this instruction? Barron asked. Marcus Blackwell, the executive editor. Barron retrieved another document from his table. Your Honor, I'd like to enter this email as Exhibit E. The email, projected on a screen for the court to see, was from Marcus Blackwell to Rebecca Chen. Remove your objections to the Trump piece. This story is a priority for us, and we have approval from upstairs to run with it. Your concerns are noted but overruled. Chen continued. When I protested, pointing out that running unverified claims violated our own published standards, I was told this was a special situation and that the Trump family is fair game. Did you keep records of these conversations? Yes, Chen said. I began recording our editorial meetings after my written concerns were ignored. Barron produced a small USB drive. Your Honor, this drive contains audio recordings of 3 editorial meetings where Ms. Chen's concerns were dismissed and where Mr. Blackwell explicitly stated they were publishing claims they knew might not be true. Reynolds jumped to her feet. Objection. These recordings may have been obtained illegally. New York is a 2-party consent state for recordings. Actually, Barron countered smoothly, Globe Media's employee handbook, which I've entered as Exhibit F, specifically states that all editorial meetings are recorded for archival purposes with consent presumed from all attendees. Ms. Chen simply made her own copy of recordings that already legally existed. Judge Miller reviewed the handbook, then nodded. Objection overruled. We'll play the relevant portions of these recordings. The courtroom fell silent as the audio began to play. Blackwell. I don't care what the fact-checkers say. The Trump kid's story runs as written. Chen. But we have evidence that directly contradicts almost every claim in the piece. Blackwell. Look, this is coming from the top. After what his father did to journalists for years, the gloves are off with this family. If there's collateral damage to the kid's reputation, so be it. Another voice. Shouldn't we at least note that these claims are disputed? Blackwell. No, we present it as fact. End of discussion. As the recording ended, the courtroom remained silent. Even Reynolds seemed stunned by the revelation. The judge's expression had hardened into one of clear disapproval directed at the defense. Barron turned back to Chen. After raising these concerns, what happened to your position at Globe Media? I was gradually sidelined, given fewer assignments, and eventually pushed to resign. Thank you, Ms. Chen. No further questions. Reynolds approached for cross-examination, but her usual confidence had completely evaporated. She tried to suggest Chen had a grudge against her former employer, but each attempt to undermine her testimony fell flat, as Chen calmly referenced additional documentation supporting her claims. When Reynolds finally returned to her seat, Globe Media's legal team huddled in urgent conversation, their body language conveying growing panic. The surprise witness and recordings had devastated their defense, providing clear evidence of actual malice, exactly what Barron needed to win his case. Judge Miller called for a brief recess. As people filed out of the courtroom, reporters rushed to file updates. The headlines were already changing. Barron Trump stuns court with damning evidence against media giant, and teen Trump's legal genius unveils shocking media conspiracy. The judge who had started the trial mocking Barron's legal abilities now watched him with undisguised respect. What had begun as a seemingly mismatched David versus Goliath battle was rapidly turning into a masterclass in legal strategy, delivered by the most unexpected of teachers. During the recess, the Globe Media legal team transformed their strategy completely. When court resumed, Stephanie Reynolds approached the bench with renewed determination, her earlier dismissiveness replaced by aggressive focus. She knew they were in serious trouble. Your Honor, Reynolds began, before we continue, the defense requests permission to call an expert witness not previously listed, Dr. Harlan Montgomery, a constitutional law scholar specializing in First Amendment cases. Judge Miller turned to Barron. Mr. Trump, do you have any objection? Barron considered for a moment. No objection, Your Honor. Unlike the defense, I welcome all relevant testimony, even when it comes as a surprise. The subtle reminder of their earlier objection to his surprise witness caused Reynolds to flush slightly, but she maintained her composure. Dr. Montgomery took the stand, a distinguished-looking man in his 60s with wire-rimmed glasses and a bow tie. His resume was impressive. Harvard law professor, author of multiple books on First Amendment law, and former clerk for a Supreme Court justice. Dr. Montgomery, Reynolds began, could you explain to the court the special protections afforded to the press under the First Amendment, particularly regarding public figures? Montgomery leaned toward the microphone. Certainly, the Supreme Court has consistently held that robust public debate requires giving the press wide latitude when reporting on public figures. In New York Times versus Sullivan and subsequent cases, the court established that public figures must prove actual malice, not merely negligence or poor reporting. And how difficult is it to prove actual malice in most cases? Exceedingly difficult, Montgomery stated confidently. It requires proving that the publisher knew with certainty that the statements were false or showed reckless disregard for their truth or falsity. Simply making a mistake, even a serious one, doesn't typically meet the standard. Reynolds nodded. In your expert opinion, should editorial discussions about the angle or slant of a story be considered evidence of actual malice? Absolutely not, Montgomery replied. Editorial discretion is the heartbeat of press freedom. Editors must be free to determine which aspects of a story to emphasize without fear that their internal debates will later be used against them. Otherwise, the chilling effect on journalism would be severe. Reynolds walked closer to the jury, and regarding Mr. Trump specifically as the son of a president and public figure, doesn't the public have a particular interest in his qualifications and achievements? Indeed, Montgomery agreed. The public has a legitimate interest in knowing whether the children of powerful people receive special treatment. Reporting on such matters serves an essential democratic function. Reynolds looked pleased. No further questions, Your Honor. As Barron stood for cross-examination, Dr. Montgomery regarded him with barely concealed condescension. Here was an academic heavyweight facing a teenager. The outcome seemed predictable. Dr. Montgomery, Barron began, you've written extensively about First Amendment protections. Have you also written about the limits of those protections? Montgomery blinked, surprised by the direct question. Well, yes, of course. No constitutional right is absolute. In fact, Barron continued, retrieving a book from his table, in your own textbook, Boundaries of Press Freedom, you wrote, and I quote, knowing falsehoods deserve no constitutional protection as they contribute nothing to the marketplace of ideas. He looked up. Do you stand by that statement? Yes, but... And you also wrote that when a news organization knowingly publishes false statements with the specific intent to harm, they're no longer acting as the press that the founders sought to protect. Correct? Montgomery shifted uncomfortably. That's a very specific context. It's the exact context we're discussing today, Barron interjected calmly. Dr. Montgomery, Are you familiar with the specific evidence presented in this case? I've been briefed on it, Montgomery admitted. Have you listened to the recordings where Globe media editors explicitly stated they knew the claims might be false, but published them anyway because, and I quote, "the gloves are off with this family"? I was told about them, yes. Barron approached with the transcript. Please read the highlighted section. Montgomery reluctantly read aloud the damning exchange, where editors admitted to ignoring contradictory evidence. Dr. Montgomery, based on your own published standards, Barron asked, would you consider this a case of knowingly publishing false information with intent to harm? The professor hesitated, caught between his academic integrity and his role as an expert witness for the defense. If these statements are accurate, then yes, this would fall outside the protections I believe the First Amendment provides. A murmur ran through the courtroom. Reynolds looked stricken. One final question, Barron said. You mentioned that the public has a legitimate interest in knowing whether children of powerful people receive special treatment. Doesn't the public also have a legitimate interest in knowing when media organizations knowingly publish falsehoods about those children? Yes, Montgomery conceded, removing his glasses. The integrity of information is fundamental to public discourse. No further questions, Barron said, returning to his seat. Reynolds attempted redirect examination, but Montgomery's credibility as a defense witness had been irreparably damaged. When dismissed, he left the stand looking shaken, having essentially validated Barron's case using his own published principles. Next, the defense called Marcus Blackwell, the executive editor heard on the recordings. Blackwell entered with a defiant swagger that quickly faded under questioning. Reynolds tried to establish that the recorded comments were taken out of context, but Blackwell's attempts to explain away his statements only dug a deeper hole. Mr. Blackwell, Reynolds asked, when you said the gloves are off with this family, what did you mean in a journalistic context? I meant we wouldn't be intimidated from pursuing legitimate stories, Blackwell replied. The Trump family has a history of attacking the press. When Barron's turn came, he approached with a calm that contrasted sharply with Blackwell's growing agitation. Mr. Blackwell, you testified that you were pursuing legitimate stories. How do you define legitimate in journalism? Stories based on facts that serve the public interest, Blackwell answered. And when your fact checker provided evidence contradicting your claims about me, did you consider those facts relevant? We had other sources. Sources you've been unable to produce during discovery, Barron noted. Mr. Blackwell, is it standard practice at Globe Media to ignore contradicting evidence when it doesn't fit your preferred narrative? Objection, Reynolds called. Argumentative. Sustained, Judge Miller said. Rephrase, Mr. Trump. Barron nodded. Mr. Blackwell, did you instruct your team to remove contradicting evidence from the fact-checking report? I made an editorial judgment, Blackwell said defensively. That wasn't my question. Did you instruct your team to remove evidence showing my academic achievements were legitimate? Yes, Blackwell finally admitted. And did you do so knowing this would create a false impression about me? Blackwell hesitated too long. I was focused on the larger story. The larger story being what? That my family deserved negative coverage regardless of facts? Objection. Reynolds stood again. Withdrawn, Barron said smoothly. No further questions. As Blackwell left the stand, his reputation in tatters, Judge Miller adjourned court for the day. The atmosphere had completely transformed. What had begun as mockery of a teenager representing himself had become a stunning display of legal prowess that had a major media company and their high-powered attorneys on the defensive. In the gallery, law students who had come to watch what they thought would be an amusing disaster were now taking detailed notes. Several practicing attorneys were doing the same, visibly impressed by Barron's methodical dismantling of the defense. Judge Miller, Watching Barron gather his materials at day's end showed no trace of his earlier condescension. Instead, his expression conveyed something rarely seen from the bench: genuine admiration. The courtroom fell silent as Barron Trump rose for his closing argument. After 4 days of testimony, evidence, and legal maneuvering, the case that began with mockery and laughter had transformed into one of the most closely watched defamation trials in recent memory. Legal experts had flocked to the courthouse to witness the young man who had masterfully outmaneuvered a team of veteran attorneys. Judge Miller, who now watched Barron with undisguised respect, nodded. "Mr. Trump, you may present your closing argument." Barron walked to the center of the courtroom, taking a moment to make eye contact with each juror. Gone was any trace of nervousness that might have been present on the first day. In its place was the quiet confidence of someone who knew he had proven his case. "Ladies and gentlemen of the jury," Barron began, his voice clear and measured, "when I filed this lawsuit and chose to represent myself, many people in this very courtroom thought it was a joke. I understand why. I'm young, I have no law degree, and I was going up against one of the largest media companies in the country with their team of experienced attorneys." He paused, allowing the jurors to recall the atmosphere from the trial's beginning. "But this case has never been about me proving myself in a courtroom. It's about something far more important: the boundary between press freedom and deliberate harm through knowing falsehoods." Barron walked slowly in front of the jury box, his hands clasped behind his back. "The First Amendment is one of our most cherished protections, and rightly so. A free press is essential to democracy. But as we've established through testimony and evidence, freedom of the press has never included the freedom to knowingly publish lies." He gestured toward the defense table. "Globe Media wants you to believe this is simply about a public figure who couldn't handle negative coverage. But that's not what the evidence shows. What you've seen over the past 4 days is something far more disturbing: a calculated decision to publish claims they knew were likely false." Barron retrieved several key exhibits and displayed them on the large screen for the jury. "Let's review what we've learned." First, we heard from Dr. Wright, who testified that Globe Media contacted her before publication and that she provided them with evidence contradicting their claims about my academic record. They chose to exclude this information. He switched to the next exhibit. Second, we saw internal emails where fact-checkers specifically flagged nearly every claim about me as unverified or contradicted by evidence. These concerns were dismissed. Another exhibit appeared on the screen: the transcript of the recorded editorial meeting. Third, and perhaps most damning, we heard executive editor Marcus Blackwell, in his own words, directing staff to publish these claims regardless of their accuracy because, and I quote, "After what his father did to journalists for years, the gloves are off with this family." Barron turned back to face the jury directly. "The legal standard in defamation cases involving public figures is actual malice, meaning the publisher knew the statements were false or showed reckless disregard for their truth. The evidence doesn't just suggest actual malice, it proves it conclusively." He paused, allowing the weight of this point to settle. "I didn't ask to be born into a famous family. I didn't choose to have my name recognized everywhere I go. But being a Trump doesn't mean I forfeit the right to be judged on my own merits or the right to defend myself against deliberate lies." Barron's voice grew more passionate, though still controlled. "This case is about more than just an 18-year-old defending his reputation. It's about accountability. It's about whether we, as a society, will allow powerful media organizations to knowingly publish falsehoods about individuals they dislike, simply because they carry a certain last name." He walked back to his table and picked up his college transcript. "I worked hard for these grades. I studied late nights. I earned my place at university through my own efforts. And when Globe Media decided to publish claims that I cheated my way in, claims they knew were questionable at best, they didn't just attack my reputation. They attack the very principle of truthful reporting that they claim to uphold. Barron returned to stand before the jury one final time. Ladies and gentlemen, I'm not asking you to rule in my favor because you feel sorry for me or because you like me. I'm asking for justice based on the facts and the law. The evidence is clear. Globe Media published statements they knew were likely false, with the specific intent to cause harm. That is the textbook definition of actual malice. He looked at each juror in turn, his gaze steady and resolute. You have the power today to send a message that the truth matters, that even the most powerful media companies cannot hide behind the First Amendment when they deliberately spread falsehoods. That's not limiting press freedom. It's upholding the standards that make a free press valuable in the first place. With that, Barron returned to his seat, leaving a profound silence in the courtroom. Reynolds then delivered the defense's closing argument, but her usual confidence had been replaced by a defensive tone that failed to resonate. She emphasized press protections and the high standard for proving actual malice, but her arguments seemed hollow against the mountain of evidence Barron had presented. As the jury filed out to begin deliberations, legal analysts in the courtroom were already declaring Barron's closing argument a masterclass in persuasive advocacy. Even those who had come expecting to see a privileged teenager embarrass himself were openly acknowledging his exceptional performance. Judge Miller, watching Barron organize his notes at the plaintiff's table, shook his head slightly in amazement. The young man who had stood before him just days ago, subjected to mockery and condescension, had just delivered one of the most effective closing arguments he had witnessed in his decades on the bench. The verdict, it seemed, was merely a formality. The jury took less than 3 hours to reach a verdict, an astonishingly short time for a defamation case of this complexity. When word came that they had reached a decision, reporters scrambled back to the courtroom, spectators rushed to claim seats, and both legal teams prepared for the moment of truth. Barron sat calmly at the plaintiff's table, hands folded in front of him. Across the aisle, Reynolds whispered urgently with her clients, their expressions tense. The brief deliberation time suggested a clear decision, and given the evidence presented, few in the courtroom doubted which way it would go. As Judge Miller entered, the bailiff called for all to rise. Once seated, the judge addressed the jury forewoman. "Has the jury reached a verdict?" "We have, Your Honor," she replied, handing a document to the bailiff. Judge Miller read the verdict silently first, his expression revealing nothing. He then handed it back to the clerk to read aloud. In the case of Trump versus Globe Media Network, on the claim of defamation, we, the jury, find in favor of the plaintiff, Barron Trump. A wave of murmurs swept through the courtroom. The clerk continued reading. We award compensatory damages in the amount of $5 million for harm to reputation and emotional distress. The murmurs grew louder. Additionally, we award punitive damages in the amount of $10 million, finding that the defendant acted with actual malice in publishing statements they knew to be false or with reckless disregard for their truth. Globe Media executives at the defense table visibly paled. Reynolds placed her hand on the CEO's arm, speaking quietly to him as he shook his head in disbelief. A total of $15 million in damages was significant even for a company of their size, and the reputational damage would be far costlier. Barron's expression remained composed, though a slight nod acknowledged the verdict. He wasn't celebrating or gloating. He had approached this case with professionalism from the start, and he maintained that demeanor even in victory. Judge Miller thanked the jury for their service and then turned to address Barron directly. Mr. Trump, the court recognizes your exceptional preparation and presentation of this case. His tone had completely transformed from the condescending mockery of the first day. In my 30 years on the bench, I have rarely seen such a thorough and effective self-representation. The judge paused, seeming to choose his next words carefully. I owe you an apology, he continued, stunning the courtroom with this unprecedented admission. I made assumptions about your capabilities based on your age and lack of formal legal training. Those assumptions were not only incorrect but unprofessional on my part. You have conducted yourself with remarkable skill and dignity throughout these proceedings. Barron stood respectfully. Thank you, Your Honor. I appreciate your candor. Judge Miller turned to address the entire courtroom. Let this case serve as a reminder of two important principles. First, that our justice system, when functioning properly, allows the truth to prevail regardless of the resources or power of those involved. And second, he looked directly at the Globe media representatives. That freedom of the press, while essential to our democracy, carries with it the responsibility to report truthfully and fairly. With a final bang of his gavel, Judge Miller concluded, "This court is adjourned." As people began filing out, reporters rushed to file their stories, many already on their phones dictating headlines. Barron Trump wins $15 million defamation, case against media giant, teen legal prodigy shocks court with historic victory. Judge apologizes after underestimating Trump's legal skills. Outside the courthouse, a crowd had gathered, drawn by the news of the verdict. When Barron emerged, there was a moment of silence before spontaneous applause broke out. He wasn't just the son of a president anymore. He had established his own identity as someone who had stood up against a powerful institution and won through his own merit and determination. As Barron prepared to make a brief statement to the press, Reynolds approached him away from the cameras. "Mr. Trump," she said quietly, "that was impressive. I've been practicing law for 20 years, and I've never seen anything quite like what you did in there." Barron nodded. "Thank you, Ms. Reynolds. You fought well for your client. If you ever decide to pursue law school," she added with a slight smile, "my firm would be very interested in speaking with you." With that surprising offer hanging in the air, Reynolds returned to her team, leaving Barron to face the press. No longer as a teenager who had been mocked and underestimated, but as a young man who had earned the respect of the entire legal community. In the days following the verdict, Barron Trump's unexpected legal victory dominated news cycles and social media. Legal experts who had initially scoffed at the idea of an 18-year-old representing himself against a media giant were now analyzing his strategy in detail, with many calling it textbook perfect and brilliantly executed. Law schools around the country began using recordings of the trial as teaching material, with professors highlighting Barron's methodical approach, commanding courtroom presence, and exceptional understanding of defamation law despite his lack of formal training. 1 week after the verdict, Barron received a personal letter from Judge Miller, something almost unheard of in legal circles. The contents remained private, but sources close to Barron revealed it contained not only a formal apology for the initial mockery, but also an invitation to consider pursuing law as a profession, with the judge offering to mentor him personally. Globe Media, facing both financial and reputational damage, issued a formal retraction and apology on their front page. Globe Media acknowledges that our reporting regarding Barron Trump contained false statements published without proper verification. We apologize unreservedly to Mr. Trump for the damage caused and are implementing new editorial standards to prevent similar failures in the future. The company also announced an internal investigation into their editorial practices, resulting in several high-level departures, including Marcus Blackwell, whose recorded statements had been central to proving actual malice. As for Barron himself, he handled his victory with the same quiet dignity he had demonstrated throughout the trial. At a small press conference on the steps of his family home, he addressed the media for the first time since the verdict. "This case was never about money or personal vindication," Barron stated, his voice steady and measured. "It was about standing up for the principle that truth matters, regardless of who you are or what your last name might be. When asked about his remarkable legal performance, Barron smiled slightly. I've always been interested in how our legal system works. When I decided to represent myself, I knew I would be underestimated, but I also knew that if I prepared thoroughly and presented the facts clearly, the truth would speak for itself. A reporter called out, "Will you be going to law school now?" Barron considered the question thoughtfully before responding. I haven't made any decisions about my future yet. This experience has certainly shown me the power of the law to protect individual rights, but I have many interests to explore. His father, visibly proud but allowing Barron his moment, stood quietly in the background, a reversal of their usual public dynamic. For perhaps the first time, Barron was being recognized not as the president's son, but as his own person, defined by his own achievements. Rebecca Chen, the former fact-checker whose testimony had been so crucial to the case, had received multiple job offers from media organizations committed to journalistic integrity. She and Barron had spoken privately after the trial, with Barron thanking her for her courage in coming forward. Sometimes standing up for the truth requires courage, Barron had told reporters when asked about Chen. Ms. Chen risked her career to do what was right. That kind of integrity deserves recognition. The case ultimately became more than just a legal victory for a young man wronged by a powerful corporation. It evolved into a cultural moment that challenged assumptions about age, experience, and capability. Law firms that might once have dismissed young applicants without Ivy League credentials were rethinking their approaches. Media organizations were strengthening their fact-checking protocols, and people everywhere were reconsidering their tendency to underestimate those who didn't fit conventional expectations. As for Judge Raymond Miller, the man who had once mockingly asked Barron where he had studied law, he spoke at a judicial conference several months later. In 30 years on the bench, no case has taught me more about the dangers of assumption and prejudgment than that one, he admitted to his colleagues. I looked at a young man without a law degree and saw someone unworthy of serious consideration. What I should have seen was someone who had prepared more thoroughly and argued more effectively than many veteran attorneys who've appeared before me. He paused, reflecting. The law is not about credentials or years of experience. It's about truth, justice, and the ability to distinguish right from wrong. Sometimes it takes an 18-year-old with no formal legal training to remind us of that fundamental fact. The case of Barron Trump versus Globe Media Network would go on to be studied in law schools for years to come, not just as an examination of defamation standards, but as a powerful reminder that in a system built on facts and logic, preparation and truth will always prevail over assumption and prejudice, no matter who presents the case.